legislative enacted. They never lie to you. They always tell you the truth, but you have to know. How many people heard people talk about the judge saying, I don't want to hear that Constitution crap in my court? Yeah. Well, listen why the judge can say that. This is In Ray Johnson's estate, 73 Pacific 424. Repeating, 73 Pacific 424. Quote, an alien has no right to raise the question of whether a statute is violative of the Constitution. This says, I don't want to hear that Constitution crap in my court. Because you're an alien. He looks at you as through his eyes as an alien. How do you get around it? Very easily. When in state court, use the state constitution. When in federal court, use the federal constitution. So when you're in state court, use the state constitution. And refer to 1849. And they're going to say, well, you can't use 1849. Well, the 1849 Constitution was written as a restriction and limitation upon the government. The 1879 is a legislative grant of powers, privileges to the people, which you're going to utilize. Very simple. Do you want to demand your rights or you want to get it as a privilege? Okay. After I started bringing this section forward in the 1990s, I think it was 93, they pulled it out of the Penal Code. This is the former Penal Code section 228. Any citizen of this state who shall fight a duel cannot vote or hold public office. I'm paraphrasing it. 232. Any person who fights a duel cannot vote or hold public office. Why do they have two sections in the 1972 Penal Code, one for citizen and one for person? Because they're two different animals. A citizen is not a person. The Penal Code says so. They removed this and combined it under assault with a deadly weapon. What happened in the 1960s? Two guys got in a duel, faced off, and they got caught. They were dueling. Well, then they tried to charge them under 228 of the Penal Code. Well, they had a smart attorney and says, hey, they're persons, they're not citizens. They're U.S. citizens, they're persons, they're not citizens, they can't be charged there. So the legislature, in their wise endeavor, made a section just for U.S. citizens, saying the same thing as one for state citizens. Just that simple. Of course, when I started broadcasting it, because I read the code, you know, and I read the laws, and I started talking about it, they repeal it and put it under 245, assault with a deadly weapon for everybody. And this says any person, but I'm not a person, so it doesn't apply to me anyway. How many people know what the definition of allodial is? Allodial, free, not holden of any lord or superior, owned without obligation or vassalage or fealty, the opposite of feudal. Like, my tie is allodial. Allodium is land. Land held absolutely in one's right and not of any lord or superior. Land not subject to feudal duties or burdens. That's allodial. Okay? I have numerous court cases at home saying all the land in the 13 colonies was given to the people in allodium. Okay? Now here's California's admission into the Union in 1850. This is what the Congress said, quote, Be it enacted by the Senate and House of Representatives of the United States of America, in Congress assembled, that the state of California shall be one and is hereby declared to be one of the United States of America, and admitted in the Union on equal footing with the original states in all respects whatsoever. All the land in California is given to the people in allodium. In fact, I can stand up here with a straight face and say they're not taxing 1 square inch of land in any state in the Union today. They're not taxing land. Valentine's 1948 dictionary. Allodial, free, not holden. In England, all lands are held by the Crown, and none are allodial. In the United States, all lands have been allodial since the American Revolution. So if they're not taxing land, what are they taxing? Subdivision lot, assessor parcel lot number, tax lot number, etc. A fiction can always tax a fiction. That's the principle of law. California in 1895 started the first subdivision plot map. They redesigned make subdivisions, and they did in 1895. In 1905, 10 years later, they decided to tax those subdivision plots. They're not taxing anything with metes and bounds. They're taxing the assessor parcel lot number, tax lot number, subdivision lot number. I ran across this one by mistake. Most of the good stuff I find out by mistake. I was doing some research on some other subject, and I found this California court case out of Sacramento about Malibu. A guy in Malibu had Lot A. Lot A here was right at the edge here, looking over the ocean. He just let it sit there. He bought it back in the 40s. He just let it sit there. In the 60s, some guy come along, and being a contractor, he bought this lot C over here, facing the other way. So he went and approached the contractor who created the lots. He says, I want you to change Lot A to over here and change Lot C to over here. So he did it. They switched the description down at the county recorder. And built a beautiful $1 million home there overlooking the ocean. So a couple of years later, this guy's driving down, he's showing his family his land that he owns right here. He's going to build a house someday. There's my, what's that house doing on my land? So he sued him. And when it got up to the Supreme Court of California, the Supreme Court says, when you buy land, you have to buy it by metes and bounds. If you buy it by subdivision lot, it's a fiction. It can be moved and transferred any place you want. I can take Lot B and put it over here, Lot C, put it over there, move it any place I want. Because it's a fiction, it can always be moved. Anyway, he won his case, you know what I mean? But the fact that the court ruled in his behalf, but it says when you buy land, you have to buy it by metes and bounds. I have a friend of mine up in, I'm not going to say what county he is, because I don't want to get him in trouble. He's got a nice lot, about 1.5 acres, house lot. And so he went out and had his lot surveyed with metes and bounds. Then he had him says, take 1 foot off the corner and leave that. Don't survey this 1 foot, 1 square foot on this corner here. And he went down the county recorder and says, I'm redescribing my lot. This is my lot, assessor parcel lot number, subdivision lot is over here. That's 1 foot by 1 foot. And all the rest is held in allodium. By metes and bounds, it can't be taxed. He's been fighting with the county for 3 years, and they've been trying to stretch it back out, and they can't do it. But he knows what he's doing. You can have all kinds of fun. If you're not having fun, you're not doing it right. What more can I say?